All rise. Please be seated.
L'audience est ouverte.
The session is called to order. Registry, could you please tell the court what is on the roll for it this morning?
Thank you, Madam President. Trial Chamber 2 of the International Criminal Tribunal for Rwanda, composed of Judge Arlet Ramaroson presiding, Judge William H. Sekule, and Judge Solomon Bosa, is now sitting in open session today, Friday the 23rd of February 2007, for the delivery of the sentence in the matter of the prosecutor versus Joseph Nzabirinda, case number ICTR-01-77-S. Thank you, Madam President.
Je vous remercie.
Thank you, Counsel for the Registry. Can the parties please introduce themselves? Let's begin with the prosecution.
Please, the court, the prosecutor appears in person, and with me are Bill Egbe, Senior Trial Attorney, Greg Townsend, Trial Attorney, and Amina Ibrahim, Case Manager, as it pleases the court.
La Chambre vous remercie.
We thank you, Mr. Prosecutor. Can the defense please introduce itself?
Bonjour.
Good morning, Madam President, Your Honors. The defense this morning is composed of Bâtonnier Jean Haguma from the Kigali Bar Association, our assistant Charlotte Moreau, our assistant Mr. Celestin Buhuru from the Kigali Bar, and myself, François Roux, lawyer with the Montpellier Bar in France. Thank you. We thank you, Counsel. As has been announced a moment ago, today's hearing is for the Chamber to deliver judgment in the sentencing in the matter of the prosecutor versus Nzabirinda. What follows is a summary and not the official text of the judgment. The written judgment will be made available to the parties and to the public at the end of this hearing. The accused, Joseph Nzabirinda, was a former youth organizer in Butare Prefecture from 1976 to 1992 before becoming managing director of Sekobe in Kigali. He was also a founding member of the Parti Social-Démocrate in 1990. He was arrested on 21 December 2001 in Brussels by the Belgian authorities based on an arrest warrant dated 13 December 2001, annexed to an indictment dated 6 December 2001, issued by this tribunal. During his initial appearance on the 27th of March 2002, the accused pleaded not guilty to all 4 counts of the indictment. On 20th November 2006, the prosecutor filed a motion to amend the indictment dated 13th December 2001. On the 8th December 2006, the motion was granted by the Chamber. Under the amended indictment dated 9th December 2006, Joseph Nzabirinda is only charged with aiding and abetting, and preparing the commission of 2 murders, a crime against humanity, under Articles 3A and 6.1 of the statute as an accomplice by omission.
L'acte d'accusation.
The indictment alleges that after the 19th April 1994, the accused attended several so-called pacification meetings. Pacification meetings is in inverted commas, in Sahara sector, Ngoma sector, Butare prefecture, where only the Hutu and killers of his sector were present.
Après ces réunions,
following the meetings, systematic attacks were launched against Tutsi families living on the accused's hill.
au cours de
During one of these attacks, the Interahamwe killed Pierre Murara near the location of the pacification meetings, in inverted commas, where Joseph Nzabirinda was present as an approving spectator. The words approving spectator appear in inverted commas.
Birinda et tout.
Joseph Nzabirinda is also charged with the murder of Joseph Mazimpaka, killed near the Kabuga roadblock, which he manned on 2 occasions after the 19th April 1994 at the request of the authorities.
L'acte d'accusation allègue.
The indictment alleges that in appearing beside the killers at the roadblock as an approving spectator in inverted commas, the accused encouraged the murder. On 12th December 2006, the parties filed a joint motion for consideration of a guilty plea and a plea agreement between Joseph Nzabirinda and the Office of the Prosecutor.
Le 4.
On 14th December 2006, on his further appearance, Joseph Nzabirinda pleaded guilty to a single count of crimes against humanity pursuant to Articles 3A and 6.1 of the statute, namely aiding and abetting murder by omission. A pre-sentencing hearing was held on 17th January 2007. The defense called 5 witnesses. The written statements by 2 witnesses were admitted by the chamber pursuant to Rule 92 bis of the Rules of Evidence and Procedure, Rules of Procedure and Evidence. The facts in support of the charges against Joseph Nzabirinda are outlined in the plea agreement. Such supporting facts, as well as the indictment, which Nzabirinda acknowledges to be true, constitute the factual basis upon which the trial chamber will determine sentence. These facts are outlined in the guilty plea as follows. The guilty plea.
L'accusé reconnaît.
The accused admitted that following the meeting held by President Sindiku Bwabo in Butare Prefecture on 19th April 1994, widespread killings of Tutsis and opponents of the regime began in the prefecture and in particular in Sahara sector. The accused admitted that he attended several meetings at the Sahara sector office where only Hutu and killers that the accused knew as his neighbors were present. He admitted that he was present at such meetings as an approving spectator. Approving spectators appear in inverted commas. He further admitted that following the meetings, systematic attacks were launched on Tutsi families living on his hill. He also admitted that during one attack, Pierre Murara was murdered at a location close to the meeting place where the accused, Joseph Nzabirinda, was present as an approving spectator. Approving spectator appear in inverted commas.
que des
Although he knew that systematic killings occurred after the meetings, the accused never stopped attending them, knowing that the purpose of the meetings was in reality to prepare and encourage the hunting down and killing of Tutsi. At the meetings, the accused did not at any time or in any manner openly object to these killings.
L'accusé
The accused admitted that as a former youth organizer, political personality, intellectual, and a relatively affluent businessman, he did exert obvious moral authority over the population of his sector, especially its youth, and over the country people living on his hill. The accused also admitted that his presence at the meetings had a decisive influence on the criminal elements in their midst, as he was a person held in high esteem by his fellow citizens, and with the circumstances prevailing in his sector, conveyed the impression of his being an approving spectator. Approving spectator appear in inverted commas. He also knew that his silence would be considered by the assailants as tacit approval of the preparations for the killings.
L'accusé reconnaît
The accused also admitted that after the 19th of April 1994, roadblocks were erected in his sector and that he knew that they were used for identity checks and were one of the means employed in the campaign of killings in the sector. That, at the request of the authorities, he had manned the Kabuga roadblock on 2 occasions along with the Interahamwe of Sahara sector. That he had encouraged the murder of Joseph Mhazimpaka by Mugenzi near the Kabuga roadblock where the accused was present as an approving spectator. Approving spectator is in inverted commas. The accused admitted that the murders of Joseph Mhazimpaka and Pierre Morara were committed in his sector at a location close to those of the meetings and roadblocks, respectively, where he was present as an approving spectator. Approving spectator appear in inverted commas. On the basis of the facts admitted by the accused, the chamber was convinced that widespread and systematic attacks had been carried out against a civilian population on discriminatory grounds in Sahara sector in April 1994. The chamber was also satisfied that the only logical conclusion to be drawn from the facts admitted by the accused was that both Pierre Morara and Joseph Mhazimpaka were murdered as a result of these attacks and because of their Tutsi ethnicity. The chamber was convinced that Joseph Nzabirinda knew that the sector meetings, which he repeatedly attended, and the Kabuga roadblock, which he manned on 2 occasions, were some of the means employed in the campaign of killings. That the murders of Pierre Morara and Joseph Mhazimpaka were part of the widespread and systematic attacks against Tutsi civilians on ethnic ground, that he knew the criminal intent of the perpetrators of the murders, that because of the moral authority he exercised, he knew that his presence at the Sahara sector meetings and at the Kabuga roadblock would be crucial in encouraging the preparation and the commission of the murders. The chamber found the accused criminally responsible not only for the encouragement that he provided as an approving spectator in inverted commas, at the preparatory meetings, but also for his attendance as well as his presence as an approving spectator close to where Pierre Morara and Joseph Mhazimpaka were murdered. The words approving spectator appear in inverted commas. The chamber held that the accused was criminally responsible pursuant to Article 6.1 of the statute for aiding and abetting the murders of Pierre Morara and Joseph Mhazimpaka in Sahara sector in April 1994. Consequently, the Chamber found the accused guilty of murder as a crime against humanity under Article 3A of the statute.
Sur l'application du principe.
On the applicability of the non bis in idem principle, the Chamber granted the prosecutor's request to withdraw 4 counts from the 13 December 2001 indictment, while reserving its ruling on the legal effect of such withdrawal, particularly in respect of the applicability of the non bis in idem principle. The Chamber shall now rule on this issue. As the Appeals Chamber observed, the term tried implies that proceedings in the national courts constituted a trial for the acts covered by the indictment brought against the accused by the tribunal, and at the end of which trial a final judgment is rendered. Accordingly, unless a person has been indicted for crimes over which the tribunal has jurisdiction, resulting in a final judgment on the merits, or after fair, impartial, independent, and diligent proceedings before a national court, the principle of non bis in idem would not apply. In the instant case, the Chamber recalls
En l'espèce, la Chambre rappelle.
In the instant case, the Chamber recalls that the charges were withdrawn when the prosecution sought to amend the indictment under Rule 50 of the rules, and that a trial on the merits was yet to commence. The Chamber therefore denies the motion.
Sur la fixation de la.
Regarding sentencing, the Chamber recalls that the tribunal was established to prosecute the perpetrators of the atrocities in Rwanda in 1994 so as to end impunity. This tribunal was also created to contribute to the process of national reconciliation, the restoration and maintenance of peace, and to ensure that violations of international humanitarian law in Rwanda were halted and effectively redressed. Both parties, prosecution and defense, recommended a term of imprisonment ranging from 5 to 8 years imprisonment. With credit given for time already served by the accused in detention. The parties further recommend that the convict served his sentence in a European country, preferably in France. The Chamber considered the following elements in sentencing: the gravity of the crime and the aggravating and mitigating circumstances. On the gravity of the crime, the Chamber finds that Nzabirinda's participation in aiding and abetting murder as a crime against humanity constitutes a very serious offense and a gross violation of international humanitarian law. On the aggravating circumstances, the Chamber finds the fact that Joseph Nzabirinda is an educated person who could appreciate the dignity and value of human life, and the fact that he abused his moral authority as aggravating circumstances in sentencing. Indeed, the Chamber considers that Joseph Nzabirinda, a youth organizer, an intellectual, and as a successful businessman held in high esteem in the community, had abused the obvious moral authority he exerted on the youth of his commune and the population of his sector.
La Chambre a retenu les...
The Chamber finds the following circumstances to be mitigating: Joseph Nzabirinda's guilty plea, together with a public expression of remorse, his personal and family situation as a married man with children, as indicia of his chances of rehabilitation, his good character prior to the 1994 events, the absence of a previous criminal record, his good conduct while in detention, and finally, the assistance he provided to certain Tutsi victims by way of moral, financial, and material support in Sahara sector and in organizing the departure of some of them to Burundi. The Chamber does not accept the following circumstances in mitigation of the sentence: Joseph Nzabirinda's offer to cooperate with the prosecution, insofar as there has been no demonstration of any substantial cooperation; Joseph Nzabirinda's form of participation in the criminal acts, and the alleged prevailing circumstances of necessity, as the plea agreement does not assert that Joseph Nzabirinda was compelled under duress to a criminal conduct, and is at any rate not substantiated by any credible evidence. While Joseph Nzabirinda's personal circumstances are relevant,
Bien que la situation personnelle...
Let me repeat. While Joseph Nzabirinda's personal circumstances are relevant in the mitigation of the sentence, the Chamber is of the view that such factors cannot play a significant role in mitigating international crimes. Moreover, the Chamber recalls that it did not accept in the instant case Joseph Nzabirinda's form of participation as a mitigating circumstance. The Chamber considers that Joseph Nzabirinda's presence at the scene of the crime amounts to a very serious form of participation that relates to a cognizant and a positive choice. The Chamber also considers that Joseph Nzabirinda did not disassociate himself from those who organized the attacks during the sector meetings, which he attended, nor from the assailants who murdered Joseph Mbanzi-Mpaka near the roadblock that he manned.
La Chambre rappelle.
The Chamber recalls that he never stopped attending the sector meetings, even though he knew that systematic killings had resulted from the first meeting, and that at no time did he, or in any manner, openly object to the killings at such meetings.
De plus, la Chambre estime...
The Chamber finds that Joseph Nzabirinda knew that his presence and moral authority would encourage the killers to execute their crimes. The Chamber has considered the general sentencing practice in Rwanda.
Voici le verdict de...
Here is our verdict. Mr. Nzabirinda, can I now ask you to stand before the bench, please?
Voulez-vous aller au prétoire, s'il vous plaît? Nous vous remercions.
Thank you. This is our verdict. The trial chamber, delivering its judgment in public, in the presence of the parties, at the first instance and in conformity with the statute and the rules, having accepted your guilty plea, having considered all the evidence and heard the parties' arguments, you are hereby sentenced on the single count of murder as a crime against humanity pursuant to Articles 3A and 6.1 of the statute to 7 years imprisonment. The Chamber further decides that you are entitled to credit for time served in detention as from the 21st of December 2001 to the date of this judgment. The sentence shall run as of today, and you shall remain in the custody of the tribunal pending a decision where your sentence will be served by the President of the tribunal in consultation with the Chamber. We thank you. The hearing is adjourned.
All rise.